Start. Learned counsel for the applicant has submitted that from the perusal of the first information report itself, it is clear that the opposite party number 2 entered into memorandum of understanding dated 14.3.2006, wherein there was agreement between the applicants and the opposite party number 2 that 25% of the profit shall be paid to opposite party number 2, full stop. Once she has admitted entering into such a memorandum of understanding, she cannot be permitted to take contradictory stand, alleging that the memorandum of understanding was forged by the applicants by concocting the signatures thereon, full stop. In case the memorandum of understanding was not executed by her, she cannot have any grievance against the applicants, full stop. In case her earlier stand that she entered into such a memorandum of understanding, then the memorandum of understanding being illegal and against the provisions of the Companies Act as admitted by Shri Sukumar Jain, advocate also in his statement before the investigating officer, she cannot get any benefit arising out of the memorandum of understanding, full stop. The above memorandum of understanding being a void document cannot be enforced through any court of law, and therefore, the entire case of the opposite party number 2 is absolutely false and prompted by ulterior motives, full stop. It has further been submitted that the Company Law Board, Kolkata branch, Kolkata, directed the company to deposit rupees 12 crore 3 lakhs 47,715 towards to the principal amount of shares along with interest to be deposited before the Company Law Board, and an application dated 3.3.2014 was moved by opposite party number 2 for release of the aforesaid amount, which was directed to be released on 31.3.2014, full stop. A settlement dated 17.9.2011 was arrived at before the Company Law Board, and the opposite party number 2 filed the same on affidavit stating that she has no dues against the company left and all the dues have been settled, full stop. However, later she denied the aforesaid settlement and filed an affidavit, but her stand was not appreciated, and against the same opposite party number 2 approached the Kolkata High Court and Apex Court unsuccessfully, full stop. It has been submitted once the proceeding of the Company Law Board have been upheld up to the Honorable Apex Court and the dues of the opposite party number 2 settled before the Company Law Board, Kolkata, in Company Petition 777 of 2010 is held to be final, there remains no dispute between the parties to be agitated before the criminal court, full stop. Para 13 dot. Time was granted to opposite party number 2 to file counter affidavit on 1.11.2018, but learned counsel for the opposite party number 2 did not want to file counter affidavit, full stop. It has been submitted that by Shri I.K. Chaturvedi, learned counsel appearing on behalf of opposite party number 2, that the application filed by the applicants is not maintainable as there is no misuse of process of law by the trial court in passing the impugned order against the illegal acts of fraud, cheating and forgery committed by the applicants, regarding which the opposite party number 2 lodged the first information report, full stop. The aforesaid offence was committed by the applicants in pursuance of Memorandum of Understanding dated 14.3.2006, and they induced the opposite party number 2 to sign the aforesaid Memorandum of Understanding, showing it to be valid and legal document, and for the purpose of investment, opposite party number 2 invested huge amount on its basis in the company. Full stop. Over.